Okay. All right. So, yeah, good evening to the people who have evening friends at this time or afternoon. I hope everybody got their exam question back. I looked at everyone's question. I did not point out a lot of mistakes, or I did not made a lot of comments, but that doesn't mean that um, your question or anybody's question is particularly wrong. I just want you to keep the general feedback open, and that's why I have made, however, a few points here and there. The one thing that I noticed, by the way, everybody did pretty much put everything there. Everybody pretty much put everything there. Like I said, this may be a couple of things that a couple of people may have missed. It's fine, happens. You can only write so much in the 45 minutes, and what you want to make sure is that the outline that you frame in your mind of your question should be enough that it's not breaking the sequence. You start from one part, and then you kind of smoothly move on to the next one, and then the next one, and the next one, and eventually you're going to conclude the question. I have not written any view. There is no sample answer for that question. I'm going to give you an outline, sort of like an outline of framework, and you guys can fill in your answer accordingly on that outline, which whenever you want. So the basic thing is that there are 4 parts of a question. You must always start with an introduction. Always start with an introduction. You don't have to like pad it or underline it or make it pretty, but just it should not be jumbled up enough for the examiner that he can get confused. He should know that, okay, this is your introduction, this is your rule of law, these are your examples, this is your analysis, so on and so forth. What I noticed that most of the answers, there was no introduction. Nobody introduced that what actually causation is, where it comes from. We just start all of a sudden from causation, and then we moved on to the legal cause and the factual cause, but for test. Your causation is actually an element of a crime. If you remember, I mentioned in the previous previous lectures when we were reading about causation, your crime, the elements of crime, there are few elements of crime in which the major ones are the action, causation, the effects of it, unless there are defenses available, the effect, which is the consequence, the damage to the victim. So that's where it ends, okay? First of all, you always want to mention what actually is causation, okay? And then you define the causation. What is causation? It is something that links the action of the actor or the defendant to the consequence that may have harmed the victim, his or her body or property or whatever your question is asking. And then you move on. And the other thing is, look, the factual cause and the legal cause, those are not elements of causation. If you get a chance, go back and look at the notes. Those are the 2 tests that prosecution uses and then the jury uses to determine whether the accountability, they can put the defendant, they can hold the defendant accountable or not. Okay, and these 2 things, your factual cause and then your legal cause, but for test, and then your proximity, substantial proximity test. You might want, there are a few phrases that you might want to mention that are also mentioned in my notes. Third thing is that after you introduce what causation is, you're going to introduce that why is it important, you're going to introduce how is it used. They're all in your introduction. And then you want to make sure that there is nothing that is breaking the chain of causation, okay, in order for defendant to be completely liable. People have used, you guys all have mentioned a few examples. Some have mentioned more than the others. then what can break the chain of causation? But oftentimes I felt like the example was given first, and then the breaking the chain of causation was mentioned later. That throws the examiner off. I should know, or as an examiner, he or she should know what she should be expecting next. Okay, if I'm expecting, okay, right now he's going to mention, or she's going to mention breaking the chain of causation, then you support it. You say, okay, oftentimes the chain of causation can be broken. It is not a part of your factual cause. No, it is just stands on its own, and it can be broken by the act of third party, by the act of victim, may or may not by the supervening act of the defendant himself. It doesn't break those. Even if act of third party for the reason of defendant's act, for example, that case where the pregnant girlfriend was used as a human shield, right? Defendant didn't act on it, but police did. She died, but defendant was still liable. So on and so forth. So once you get the format, you just fill those things in, okay? After your analysis to everything, then you guys gonna go down and conclude your question. Don't abruptly finish it. It's just I'm reading, it's like reading a really interesting story, and all of a sudden it says, what? It just finished like that, just like that. No, don't do it. You conclude your question. Conclusion and introduction are very similar. Always remember, if you ever have written a thesis, your introduction can also be a thesis statement. Conclusion, you're not going to copy exactly what you're going to write in the introduction, but you're going to mention that thus or therefore, if blah blah, the defendant does this, it happens this, and you apply this rule there, it's going to conclude it into the accountability of the defendant. Okay. Another thing is people are being concerned about mock exams. The reason in the idea of mock exam is for you to know how much we have studied, how much we exactly have understood, and how much do we need, and what are the areas where we are making mistakes. Okay, so do your mock exams in time and send it to me right after the class is finished. We're going to be doing that periodically more, and I want to see that how much, and you also want to see for your own feedback that how much exactly can you produce. Okay, there is a lot. That was a long question. That was a really long question. You guys did a great job on it by providing all the information. So just do it. Keep it in time. Don't take extra time to write a long essay, because you are not going to be preparing yourself this way for the exam. In exam, you're not going to get more than 45 minutes. And then if you don't finish the question, you're going to have to move on to the next question so you don't lose time. If you find time later on, you can come back and finish the question that you have left in the middle later on. But never, never, never spend too much time on one question. Time management. Okay. Examples. About examples, there was a couple of people have written the feedback. There were tons of examples. Good. But yeah, you use examples. They're good examples, but instead of quantity, focus on quality. So your examples are not going to tell examiner anything unless you have explained the idea. Okay. So you explain what but-for test is. You explain how it's done. You explain. Then you can say, yeah, but-for test. In this ruling, court held that but-for test is this, and that's how it should be used. For example, we learned that the legal cause was going through a lot of changes, up and down. It was fluctuating a lot, but eventually what the current law is that it should be your proximity test, right? And if the initial act of defendant keeps carrying on up to the point it's serious enough, all that stuff. So pick one example or two examples that really proved your point, and then you move on to the next topic. If you get time, go on, come back and put in more examples, but little bit is better than a lot of them. But if you cannot send your message across to the examiner, examples are not going to help you. Your examples are there to facilitate your argument, your definition, or your answer. Okay, examples are not your answer. Okay, lost connection. Can everybody hear me? It looks like Sandeep has lost connection. All right. All right. Okay. It was an open book exam. I did not want you to, but open book doesn't mean that you copy everything, then you're going to lose time. Open book is for reference. Usually in your exam, I am not quite sure how much you can take. I have to find out for you, but I know you can take the book of statutes. And I think last I checked, that was the only thing you can take. So just focus on, just use your memory. You don't have to memorize a lot of stuff as long as you understand the concept. And your book and your guide recommends, your school recommends that you know a few phrases that are very important, key phrases, like foreseeability or the proximity test or the legal terms. Some of them you're gonna, during the course of this course, you will be able to memorize them without any extra effort. So you can add those in, and don't worry about making your question really pretty. It should be just neat enough, clean enough to for the examiner to read it. Okay? Any questions? No questions? All right. If you have any questions, just write it down. I'll answer them periodically, or maybe at the end of the lecture. Today we're going to move on to homicide, criminal homicide. Finally, criminal homicide includes your murder, your killing, manslaughter, all that stuff. It's a huge topic, and it's a huge area, and you most often get at least one question from this, either murder or manslaughter. So you should be able to know both, and you should be able to know that when to switch from murder to manslaughter, because there's a little bit difference between the two. You don't always get the murder conviction. Most probably what your examiner is going to test you on, murder is a very straightforward, unless you have an essay question, they're not going to test you, that's my understanding, on murder straight. It's very straightforward. There is not a lot in there. There are a few developments though. It's important, however, and for you to know murder completely is important in a way that murder conviction can be switched down to manslaughter with a very little tiny difference. So you should be able to analyze the facts if you get a fact question on this, and if they are calling for the judgment from you, that, for example, okay, define these, look at these facts and all those 3-4 questions, and then there may be another little question that how should the jury convict this defendant? Okay, should he be convicted for murder or manslaughter, or should he be acquitted? So you should be able to analyze those facts based on the law and based on the facts that whether that person should be convicted of murder or manslaughter. All right? Okay, what is homicide? Homicide is killing of a person. Okay? There are few types of killing. There is a lawful killing. There are unlawful killings. Now, lawful killing does not mean that you are allowed to kill somebody just on the street, just like that. No. This comes into play when you have a certain defense to you, okay? For example, self-defense. defense for yourself or the defense of another, maybe your family member, maybe your friend, maybe a stranger in certain cases, okay? Self-defense allows you to, with certain restrictions. When we read about self-defense, we'll read about what those restrictions are. This kind of killing is justified, okay? All other killings are unlawful killings. Those are completely unjustified. For example, murder, your manslaughter, death by dangerous driving, infanticide. Infanticide is, there's an act on it in UK. It's about that if a woman kills her baby, okay, different circumstances, if a woman kills her baby under 12-month-old, when we read about it, we'll see how that goes on. But there's a whole act about it. I guess a lot of that happening in the old times. So that's also not allowed. You can't kill your baby. Then you have your manslaughter. There are two types of manslaughter in unlawful killing. It's a voluntary manslaughter and involuntary manslaughter. In U.S. law, they are similar. There are similar things in U.S. law too, and but there's a little bit of a difference. But since the U.S. law is also common law, but of course here we're gonna focus on common law in terms of United Kingdom. Okay, let's move on to homicide. Okay, homicide in terms of actus reus. Actus reus, everybody knows it is the act. It's defined as the killing of another human being. So your actus reus will be an act of killing, obviously. Homicide is the killing of another human being. It's an umbrella topic, umbrella term that encompasses both lawful and unlawful killing. Okay. The common elements in the criminal homicide are going to be the killing that comprise all different, whether it's voluntary, whether it's involuntary, whether it's infanticide, whether it's self-defense, justified killing. They're all going to have one thing in common, which will be the death of the victim, the killing. And unlawful killing and of a human being as your victim. So you have killing that is unlawful, that is of a human being, and then the human being turn into your victim, okay? All right. So killing requires an act, or in case of murder, the gross negligence manslaughter and gross negligence manslaughter, but not constructive manslaughter, okay? Your element could be act or gross negligence. It applies only to living humans, not the fetus in the womb. Although a fetus, a baby is alive, there is debate in the development of law. Courts debate back and forth that a baby, whether it's alive or not, it depends on the viability. And they said that even if the baby is alive full term, if it's still inside the womb, it's not considered as a human in terms of for the defendant to be accountable for murder. Okay. One of your cases also said that once a baby is delivered, even though umbilical cord is still attached, which means the reason is that when umbilical cord is still attached, it means it's still attached to the body of the mother, right? But it's fine. It's going to have the status of a human in terms of killing. And if you kill that baby, the defendant is going to be liable. Euthanasia or dwelling. Consent says, euthanasia is that when you, by consent, somebody, for example, somebody is very crippled and they can't eat, they can't do, but they want to die. And mercy killing, a mom in one of the cases gave extra amount of heroin to his very ill son and to kill him to end his misery, but it's still murder. Okay. Consent or mercy killing is no defense. Consent is no defense was held in R. Nicholson. That is a 2012 case, a very recent one. If a person refuses to get treatment, that's your defense. Okay. We read one of the cases in the previous lecture. that said that, and you guys also mentioned it in your question yesterday. Some of you mentioned that a person refused to get blood transfusion because of religious reason. There was another person who refused to get amputation of the finger. Okay, those are the defenses, and in that case, if the victim dies, the hospital is not liable. The doctor is not going to be liable. That was held in the case of St. George and then NHS, or is it NNHS? There may be a typo here. I'll check for you. Healthcare Trust versus F. It was a 1998 case. Okay. Then there's, for example, a death resulting in bona fide surgical procedure negates unlawfulness. It means that a person is undergoing a surgery with his consent and he or she dies during the procedure. As long as the doctor was not medically negligent, as long as there was no gross negligence as to what he was doing, he was not supposed to do, for example, he's not going to be liable. Okay? Where there is no intent to kill, for example, okay, now what is constructive manslaughter? Does anybody know what is constructive manslaughter? I mentioned that the constructive manslaughter involuntary is not included in that. Okay, a constructive manslaughter is the act of killing where there is no intent to kill, but it has happened during the commission of illegality of something else. For example, an omission in the breach of duty. You have a duty not to run the red light. Got to stop there. But you just run the red light and somebody dies. Involuntary, constructive. An omission in breach of duty or killing by running a red light, like I said. Accidental death, for example, they are not blameworthy. Self-defense is allowed in certain circumstances. So those will be included in your lawful killing, not the constructive killing, but the accidental or not blameworthy killing, for example, the death resulting in the bona fide surgical procedure, self-defense, and other defenses like that we'll see. Killing of the fetus. Okay, there's a question that if the killing of a fetus causes the death of the host, can that be treated differently from not murder? It depends on the circumstances whether you can't have an intention to kill the fetus and you say that I did not have intention to kill the mother. That's my understanding. The host is obviously going to die. Depends how are you trying to kill the fetus. It depends on case-to-case basis. Like, also remember, there's also gross negligence involved in it. Okay, you really don't have the intention to kill the mom or the host, but you wanted to kill the fetus. But in return, you killed the mother. Okay, with the fetus. So, what your action, the way you tried to kill the fetus, was grossly negligent enough that you knew that mom is going to die or mom is sure to die if you're going to kill the fetus that way, then yeah, it's going to be murder. Or at the least, it's going to be voluntary manslaughter. Okay? When we read about infanticide, and when we read more about this killing of a fetus in the womb, I will note down this question and I'll look for it and I will send you the answer to it, okay? Okay. Causes of death. Okay, so we all know by now that the burden of proof is on prosecution to prove that they must prove that dependent cause of death of the victim. The usual rules of causation apply, both factual causation, the but-for test, and the legal causation. And defendant's conduct need not to be the sole cause of death, but it must make a significant contribution to the death of the victim. We read that in Paget, 1963. So same rules of causation are going to apply to the murder as well, or homicide as well, I should say. Okay. It is important to understand the relationship between murder, voluntary manslaughter, and involuntary manslaughter. Okay. All offenses share a common accessory as that the defendant unlawfully causes the death of another human being. Murder is more serious because it requires the highest form of mens rea, an intention to kill or cause grievous bodily harm. So murder is your most serious crime of all in the homicide. After murder, you have voluntary manslaughter. There are certain defenses available which brings the murder down to voluntary manslaughter, and some of them, just to touch base on them quickly right now, are the loss of control. Okay, there is it's also called loss of control is also called causation. This is how you reduce the liability from murder to manslaughter, and the both actus reus and mens rea present for murder, as if he has both actus reus and mens rea present for murder. Okay, these are the special partial defenses that I'm just ready to mention. For example, loss of control, like I said, and the diminished responsibility and the suicide pact. We're going to read about it in defenses. Your loss of control, you probably have heard the term provocation. Provocation is used in U.S. law a lot, and the U.K. law just use the term loss of control, but they are both the same thing. In voluntary manslaughter, defendant unlawfully causes the death of the victim, but he does not have the mens rea for murder. That is, no intention to kill or cause grievous bodily harm. Then you have involuntary manslaughter. Those are unlawful acts, manslaughters. There's gross negligence manslaughter. There is the reckless manslaughter. There's corporate manslaughter. We're going to go further when we read about involuntary manslaughter. We're going to read those in details. I don't want to touch them right now, so we don't deviate from the main topic, which is the murder, the homicide right now. Now, I'm going to ask you that. I just mentioned it a little bit. How and when is the liability reduced to manslaughter? A defendant kills somebody and he's been charged for murder, but the defense is trying to bring it down to the lesser charge, which is the voluntary manslaughter. How can they do that? What do they have to prove? What do you mean by lesser degree of intention, Sandeep? Okay. Remember that the actus reus and mens rea of murder, if the defendant unlawfully causes the death of the victim but does not have the mens rea of murder, which is intention to kill or cause grievous bodily harm, then your charge may be reduced to voluntary manslaughter. Okay, defendant kills, but he did not intend to kill, okay, or cause grievously bodily harm. That voluntary manslaughter. There is somebody just mentioned burden of proof beyond the reasonable doubt. Remember that always prosecution has the burden to prove beyond the reasonable doubt. Burden only shifts in certain circumstances when you are raising an affirmative or partial or impartial defenses. In case you raise the defense, then you have to go on and convince the jury that we had that defense. But the burden of proof beyond the reasonable doubt is always going to be on prosecution. It does not usually shift towards the defendant. Okay. Yes, loss of control is one of the defense, and that's when the defense raised that defense, then my client did not have intent to kill or cause grievously bodily harm. Okay. Then the charge can be reduced to voluntary manslaughter. Good. Here I have prepared a little chart for you. Here are some elements of homicide. Okay. So homicide includes murder, voluntary manslaughter, involuntary manslaughter. You don't have to write it down. I will give you that chart myself. I will put it on the Word doc and post it for you guys. So let's see that. What are the elements? Murder. Elements of murder. Actus reus is for murder is unlawfully causing the death of a human being, compared to voluntary manslaughter. The actus reus of murder, same thing, unlawfully causing the death of a human being. Involuntary manslaughter, same thing, unlawfully causing the death of a human being. Now, actus reus, notice it's the same for all three of those. The difference is in mens rea. The mens rea for murder is intent or intention to kill or cause grievous bodily harm. Voluntary manslaughter, same mens rea, intent to kill grievously or cause grievous bodily harm. But involuntary manslaughter, no mens rea for murder, no intent to kill or cause grievously bodily harm. I just said that voluntary manslaughter, if you don't have a mens rea for murder, it can get down to from murder to voluntary manslaughter. But how my chart is saying that you have an intention to say mens rea for murder. But what happened here? Well, the charge is reduced, the severity is reduced because, look at the third line, it requires a partial defense such as loss of control, diminished responsibility, suicide pact, or infanticide. That is going to bring your murder conviction out of the window, and it's going to bring it voluntary manslaughter in, right? There's another difference between that distinguished murder from voluntary and involuntary manslaughter. Murder carries a mandatory life sentence. It's a mandatory life sentence, okay? In the voluntary and involuntary manslaughter, it's a discretionary life sentence. Maximum the sentence that can be awarded is up to life. That's maximum. But it's always discretionary. You don't have to do it, okay? But depending on the severity, depending on how well the case is pleaded, whatever the circumstances in the courtroom may be at that time, they are going to bring the life sentence down from maximum life. It can be 2 years or whatever, but it's going to be maximum. Okay. Now, murder. Murder is a common law offense and most serious one in our criminal justice system. Seriousness of murder is reflected by the mandatory life sentence, as we just saw in the previous slide. Previously, it carried death penalty, but the death penalty was abolished by the Murder Act of 1955. Now it comes with a mandatory life imprisonment. Now, you may have seen in or read on news that a person killed somebody. He was, in prison for murder, but they are walking around out of the jail. How does that happen? How are they out? They got a mandatory life sentence, but they're not in the jail. Why does that happen? Does anybody know the reason? Life sentence is usually your whole life. If it's reduced or if they bargain for sentence, so that means they're going for lesser charge, which is going to be manslaughter. They are even anytime a defendant is pleading guilty or there is some kind of bargain going on between the prosecution and the defense, they are probably going asking something from defendant in return, and they're gonna bring the charge down to voluntary, and it's a huge deal for a person who is going down for murder. Okay, what happens is there's a term called tariff, Tariff. Okay, now the judge now the murder comes with the mandatory life imprisonment, and the judge at that time also set a tariff, which means it's a minimum, which is the minimum term that the defendant must serve in the jail. Okay, can be 5 years, can be 10 years, can be 15 years, and after that stay in the jail, he has to stay in jail up to life unless the parole board allows him to be released on license or bail or parole for the rest of his life if he is no longer considered a threat to public. What does it mean? It means that a parole board is going to decide that looking at his attitude or behavior within the jail during those months that he must stay in jail under tariff, they're going to see that whether this person has mended his ways or not, whether this person is considered a threat to society or not. Is he going to go out and go kill another somebody else? If not, and if they're satisfied that he is not going to be threat to somebody else, they can let him go on bail. That doesn't mean that he is acquitted. It only means that he has been allowed to go out of the jail and go live his life as is. But the parole board and his parole officer is going to keep an eye on him. They're going to stay in contact. They're going to keep an eye on his activities, see what he's doing, what he's not. And as soon as he violated his parole, they're going to put conditions on his parole. They're going to say you cannot, for example, do this. You cannot go to the particular area of town. You are imprisoned in Manchester, so you're not going to go to London. You're not allowed to go to London. If he does go to London, for example, boom, he violated his parole and he's going to go back to the jail. Okay? So remember, if you see that somebody was out on tariff, that's what it means, that he was allowed to get out of the jail and to live his life as normal, but it has conditions to it. Some people just are let out with the ankle bracelet, which means that it has a monitor in it that keeps monitoring them, that wherever they go, they put tabs on his activities. And the person can be recalled anytime if he commits another offense or violates his parole conditions. All right? Any questions so far? All right. Moving on, still talking about accessories. Unlawfully, these are the elements of the accessories. Lawfully would be, like I said, self-defense, defense of another, defense of a necessity, which is under the RA Children Co-Joint Twin Surgical Separation 2001. It is that there were twins and they were co-joint, they were like connected together on their bodies with each other, and the doctor bona fidely performed, obviously with consent and everything, tried to perform a surgery on them to separate the twins. One of them died. The doctor was held not liable because it was a bona fide surgical procedure. That's what you're in reference to A Children Co-Joint Twin Surgical Separation 2001 states. Okay. Then the other one is causing death. Like I said, we already touched upon it. The rules of causation apply, factual and legal. Of a human being, a reasonable creature in being, not the fetus in womb, like I mentioned before. The case of Fulton in 1832 and Reeves, 1839. Fulton said that a baby is a reasonable creature in being when the whole body of the child is brought alive into the world, which means he is delivered. Okay? And Reeves go on in 1839 and adds to that a child in being, even if the umbilical cord has not been cut, is still attached. A fetus in its mother's womb, other than that, a fetus is in his mother's womb is not a reasonable creature in being, and thus is not capable of being murdered. Okay? So, like I said before, even if the umbilical cord is attached, even though it's still attached with his mom's body, he is still going to be a child in being or a human being in alive in existence because he has already been delivered. What about pets? Do you think that if somebody kills my cat or dog, he's going to be charged with murder? Why not? Good. Yes, of course. They're not humans, even though we treat them like humans. I love my cat. She sleeps in my bed. She eats food, her food when I'm eating mine. I mean, I talk to her. I pat her. We treat our pets like humans, but it doesn't make them human. But if somebody kills your pet, an animal, or another animal, he can be charged under criminal damage because pets are considered the property. Okay, another variation is, what about the people on life support? They're in coma, they're on ventilator, they can't breathe on their own, they can't move, they can't do anything. What about that? In your case of Marshrak, yeah, that is murder. A case of Marshrak holds that in Steel 1981 that even though a person is in coma, is in on life support, he is still a creature in being, he is still a human being. There was another case in which it was discussed upon that whether a doctor, if he turns the life support off, whether he's going to be eligible for, whether he's going to be liable for murder or not. Okay. So the case of Airedale NHS Trust versus Bland in 1993 decided that an omission rather than a positive act is excusable for a doctor. It means, okay, you tell me what it means first, and then I'll explain. What does it mean that an omission rather than a positive act is excusable? What would be omission in that case? And what would be the voluntary act that will put doctor under murder? Okay. The court said in that positive act, for example, doctor deliberately give him poison to end his life. That's a positive act. Positive doesn't mean the connotation positive. That means that, yeah, there is an active act going on. A person who's on life support, give him something, give him, you know, poison through a syringe or something or IV, and that kills the person. That's murder. But if the doctor decides not to continue with life support anymore, it's not helping, it's not doing anything, there is no change in patient's condition, whatever the decision the doctor makes with the family. If he does that, you know, everything has a reasonable amount of time. If the reasonable amount of time is passed and they decided that it's not going to make any difference in, for example, in a person's condition, and the life support can be ended now. If they do that, then it's okay. If it was a decision, okay? That's what it means, that by ending the turning off the ventilator, that would be okay. Now, somebody asked a question whether somebody tried to kill the fetus and the host dies. Would that be a murder? Yes, it would be a murder depending on the intention, mentally active, all those that we have read. How do you? But if somebody does kill the fetus, if it can be murder, how would you? It's still killing a baby in the womb, although it's not a human being. It's still a crime. How would you make that defendant liable? Well, what would you do? If it's not murder, then what it is? Oh, remember, it's not. He's not a human being. He's not a person in being yet. He's still a fetus. Think about abortion. Think about illegal abortions. There is actually an act that we may or may not see. Well, but we're not concerned about host right now. We are only concerned about the fetus. So even if it caused grievous bodily harm to the host, it's going to be treated for the host separately. It's not going to affect the fetus as a victim. There are other acts out there. You wouldn't think that the law would just ignore it, right? If somebody kills a fetus, is it going to go free? No. They have laws about it. There's an act called Abortion Act 1957. It can be an illegal abortion is performed on a person. He can be charged on that. There are offenses against Person Act 1861. Now, there's a difference when law defines a human being and a person. A company is also a legal person as well. Okay, remember that. So, don't confuse it that, well, law says the fetus is not a human. Then how can he be considered a victim under Persons Act? The person definition of person is completely different. Offenses against the Person Act 1861 or Infant Life Act 1929. Okay. There are other ones. If you don't have a liability for a certain type of victims in one case, then you almost always, pretty much all the time, you will have something else on the side by law to get the defendant, get them to liability. Yes, there are laws about abortions that they should be done by a qualified practitioner. It should be done within this time period of the pregnancy. The rule of viability comes into play then. Then there's a lot of discussion on viability. Then at what time, until the what term in pregnancy, a fetus is considered viable. If it's viable, then don't abort him. If it's not viable at that time, it can be allowed to be aborted in certain circumstances. Yeah, see that she got the nurse got in trouble for not being a qualified practitioner. Sometimes you can get in trouble when you perform an illegal abortion. When it's illegal because the fetus was viable already. So the person who performed the abortion would be charged. Okay. There are other variations to it. U.S. law has a lot of detailed laws on it, because by Constitution you have a right for abortion, but states are, in United States, states are allowed to make their own rules how to regulate abortion. They can't just say that abortion is illegal. They have to regulate it, okay? So they have different, exactly same thing in common law that we are reading. We may get to see it later in the course, that there are some conditions placed on abortions as well. there's a reason that certain abortions are considered illegal. Okay, so ending it with Airedale, like I said, the court held in that the switching off life support machine amounted to an omission rather than a positive act, so the doctor would not be criminally liable for withdrawing treatment, but he would be if he administers a legal or lethal drug to end his life. Not legal, lethal. All right, moving on. We're still on the elements of murder. Stone has a definition. I did not quote it here. It's mentioned in your guide, and because later on the definition was changed. There was another element under the Queen's Peace. You should know that term. I mentioned it here. Queen's Peace means that in the time of peace right now. England is not at war. There is emergency is not declared, so it's Queen's Peace. Where defendant kills an enemy combatant during times of war, he has a defense to the charge of murder because it's war. In the times of peace, if he kills the same person, he's going to be charged with murder. Okay. There was also a year and a day rule. It used to be that a death must occur within a year and a day of the act or omission of the defendant. Okay. So he, for example, he seriously injured somebody, and he didn't die until a year. But that rule is abolished. That rule is abolished because science has made a lot of progress. Now you can keep the person on life support. Now you have better medical treatment. You have other forms of treatment available. So, I mean, a person can live longer than a year and then later die from the same disease 5 years later. Remember causation. Okay. Now it's 3 years after the act or omission. There's a typo. It should be or, not of. Act or omission. But after 3 years, if it happens after 3 years, you need a permission from the Attorney General. And before the prosecution goes and charge the defendant for murder. Okay. So the voting rule is abolished, but now they've extended to 3 years. But to figure whether also, law doesn't want you to charge the wrong person. Law doesn't want you to charge a person whose act or omission, he may have done it 3 years ago, but the death really necessarily came from him anymore, you know. So you really need the Attorney General's permission, so he can figure out whether this person should be charged or not be charged for murder anyways after all these years. Okay, mens rea. Intent to kill or cause grievous bodily harm. Before, in the definition of mens rea, it was written as malice aforethought. It's been repealed because in English, 2011, they said that aforethought is misleading because it implies the degree of premeditation as a requirement in the offense. But a murder may be committed on the spur of moment without any planning or premeditation. Premeditation, yeah. No requirement for malice either, because mercy killings, like I mentioned in the beginning, that a mother is she cannot see her son in suffering anymore, so she administers a high dose of heroin to end his life. Mercy killing, okay? Still a killing. It's not a defense. It's still a killing, and that's why they don't have the requirement of malice in elements of murder in mens rea anymore. English also said in 2011 that mercy killing is no defense, so don't use it as a defense. If your facts, the question says that something like that and the mercy killing and they're taking a defense, make sure you mention these two, that malice aforethought was repealed because it was misleading, and also there is no requirement for malice anymore because it negates the idea that mercy killing, it cannot be murder. And you can mention English and Cunningham both in there. Okay, the intent to kill or cause grievous bodily harm were decided in Vickers, 1957. And they also said that recklessness is not sufficient for murder. Recklessness is not sufficient for murder, just recklessness. No, it can be for manslaughter at times, but not murder. Forethought, I already mentioned, it was just been repealed. So you shouldn't be mentioning any definitions as the current law which has malice aforethought mentioned in there. Now, malice has different kinds. There is express malice, there is implied malice, and there is constructive malice. Constructive malice is the felony murder. It's been abolished. There's only express malice and implied malice that's used in order to determine whether there was an intention to kill or intention to cause grievous bodily harm. It's not a element of murder per se, but they still use malice to determine the motive or to determine the intent. We'll read about it in detail later on in the slide. Now, when it says grievous bodily harm, what is grievous bodily harm? It's a really serious harm. DPP versus Smith, 1961. We read that case before. Really serious harm. It has to be serious enough to eventually cause death or at least a lot of suffering. For example, there was a case where a person tried to cheat a mob. What do you call it? A Don of an illegal gang. They tried to teach one of the members a lesson, and they broke both of his kneecaps and left him on the sidewalk. He left him on the sidewalk, and he dragged himself up, but he fell on the street, and he ran over by a car and died. Even though he did not intend to kill him, but he caused him grievous bodily harm in such a manner that it has caused his death eventually. If he did not have his kneecaps broken, he probably would be in a better position to not move himself away from danger or whatever the case would have been. But he left it there. That was his mistake, and it said that he was he's going to be reprimanded for that. There's also direct and oblique intent that comes into play. If you remember, I'm not going to go in detail on that because we have already read about it. I'm just going to touch upon it. That direct intention is, if you remember, it's person's aim or purpose, something that he desires. He desires to kill, and he foresees that if it's going to kill, if it's going to hit this person, he's going to die. That's your direct intent. Then there's oblique intent. It's the foreseeing the consequences as virtually certain to occur. That we read in Metric and Woolen, if you remember from causation previously. Okay, so summary until now. The defendant will have the mens rea for murder if he desires and foresee the death of the victim, or he desires and foresee that the victim will suffer grievous bodily harm, or he does not desire the death of the victim but foresees it as virtually certain to occur, or does not desire to cause the victim grievous bodily harm but foresees it as virtually certain to occur. Your jury direction in murder is always going to be the standard jury direction. They are not going to define intention except that the intention is different from motive, because we read before, remember, that we try to define intention and jury can swing the other way, and then they said that don't define intention because you really can't define intention as recklessness. You really can't define intention as omission or other things like that. It's going to be a standard, simple, straightforward direction, jury direction. Now, if you see here in the top part where it says defendant will have mens rea for murder, if he, all these variations, they are different, okay? Some of them have desire, some of them have foreseeability. One or the other is missing, but something else is added. So make sure you know and you keep in mind all these different variations so you know whether the charge is a murder or not, okay? Because if one of them is some of them is missing. For example, he desires, but he does not foresee the death of the victim, and his action is not grievous enough that it's reasonably certain that he could foresee the death of the victim, then he's not going to be liable. Okay, just as an example. Okay, there was a reformation in murder. Before it used to be two-tier structure of murder and manslaughter to new. They moved it to new three-tier structure of general homicide offenses. I'm just going to quickly skim through this, and we'll continue with the same slide next week because we're running out of time. So I'm just going to leave it open for you guys for now and just tell you a little bit about it. How do you differentiate now? The murder is first-degree murder, second-degree murder, and then manslaughter. Why is manslaughter here? Manslaughter is here because the mens rea and excess rea is the same, right? But it's manslaughter because they have some defenses available. Why reform murder? There was major problem was that it was a mandatory life sentence, and same sentence for a cold-blooded killer and a misery killer. So it didn't seem fair, and they decided to reform it to cater to different degrees of severity in the actions of the defendant. So they have now first-degree murder, second-degree murder, and manslaughter. And by the way, this recommendation came in 2006. So as you can see, they have differentiated with a sentence where defendants has sentence is mandatory life sentence, and first-degree murder will be where defendant has killed intentionally or kills with intention to do serious injury with awareness of serious risk of causing death. Second-degree murder is the maximum discretionary life sentence, and it's where defendant kills or intends to do serious injury, kills with intention to cause serious injury or a fear or risk of injury, and he was aware of the serious risk of causing death. Or he can kill, and there's a partial defense of what would otherwise be a first-degree murder without the partial defense. Now then come the manslaughter. It's again the maximum discretionary life sentence, and he kills through gross negligence as a risk of causing death, or kills through the criminal act or intent to cause injury, or where there was awareness that the act involved a serious risk of causing injury. Or he has participated in a criminal venture, for example, felony murder, where the participant commits first-degree or second-degree murder in circumstances where it should have been obvious that first or second-degree murder might be committed by another participant. If he knew that we're going to go rob a bank and my friend is hot-headed, if the cashier is not going to give me money, he's going to shoot him, yeah, he's going to be liable. And then for manslaughter, it comes your voluntary and involuntary manslaughter. Okay, we're 4 minutes over. We are out of time. Once we're finished with this lecture completely, I'll give you the some of the notes. I still owe you notes from another lecture, and I promise you'll get them shortly. Okay, and the reading is going to be the same for next week. Try to go through the murder, whatever we have read now, and move on to manslaughter and voluntary and involuntary manslaughter. Hopefully, with the next lecture, we'll finish those two concepts as well. Okay. I will, if you don't have any more questions, I will see you guys next week.